When people think about the justice system, most of what comes to mind isn't actually Canadian. It's American. Courtroom dramas, police procedurals, high-stakes trials. They've shaped how a lot of us picture crime and punishment. But here's the reality. Even though Canada and the United States seem similar on the surface, their legal systems operate in very different ways. This video is all about breaking down those differences, cutting through the myths, the TV influence, and the assumptions to show how each country actually handles criminal law. And to really understand that, you have to start at the foundation. Because the biggest difference isn't in the courtroom, it's in how the law itself is built. In Canada, the system is unified. There is one central rulebook, the Criminal Code of Canada. This single code applies across the entire country, meaning the definition of crimes and the structure of the law are the same no matter where you are. From major cities to small, rural communities, the legal framework doesn't change. That consistency comes from how Canada is set up. Criminal law is controlled at the federal level, so when laws are created or updated, they apply nationwide. The goal is a system that is predictable and uniform, where the same behavior is treated the same way across the country. Now compare that to the United States, where things are far more complex. Instead of one unified system, the US operates under multiple layers of law. Each state has its own criminal code, and the federal government has its own set of laws as well. That means there isn't just one system. There are over 50 working at the same time. And those differences aren't just technical. They can actually change the outcome of a case. The way a crime is defined, the severity of charges, and even the penalties can vary depending on which state you're in. Something treated one way in one state could be handled very differently just across a state line. On top of that, federal law adds another layer, typically dealing with crimes that involve national interests, cross-state boundaries, or federal agencies. So instead of one consistent framework, you end up with overlapping systems that can apply in different ways. This is often described as a patchwork approach to criminal law. There's also a key concept behind it, called the dual sovereignty doctrine. In simple terms, it means state and federal governments are treated as separate legal authorities. Because of that, a single act can violate both state and federal law, and in certain situations, be prosecuted in both systems. That kind of overlap doesn't exist in Canada in the same way, because criminal law isn't divided between different levels of government. So right from the start, you're looking at two completely different approaches. Canada builds its system around consistency and a single national standard. The United States builds its system around multiple jurisdictions and local control. And this one difference, how the law is structured, sets the stage for everything else we're about to break down. Once someone has been found guilty, the next step is sentencing. And this is where another major divide between Canada and the United States becomes clear. It's not just about how long someone is punished, but how that punishment is decided in the first place. In the United States, sentencing is often built around structure and consistency. Many jurisdictions use detailed sentencing guidelines that outline specific ranges of punishment based on the crime and the person's criminal history. In some cases, laws require judges to impose mandatory minimum sentences, fixed penalties that must be applied once certain conditions are met. This approach became especially prominent during the tough-on-crime era, where lawmakers aimed to create stricter, more predictable consequences for offenses. Policies like three-strikes laws were introduced in some states, meaning that after multiple serious convictions, a person could face a significantly increased sentence, sometimes even life in prison. The idea behind this system is uniformity. Two people committing similar crimes should, in theory, receive similar punishments. By limiting how much discretion a judge has, the system tries to reduce inconsistency and ensure that sentencing follows a clear, standardized structure. Now compare that to Canada, where the philosophy is very different. In Canada, sentencing is guided by principles rather than rigid formulas. The Criminal Code of Canada sets out the purpose of sentencing, which includes not only punishment, but also rehabilitation, deterrence, and protection of the public. Within those guidelines, judges are given significant discretion to determine what sentence is appropriate for each individual case. That means a judge doesn't just look at the crime, they look at the person. Factors like background, personal circumstances, level of responsibility, and the context of the offense all play a role in shaping the final outcome. One important example of this approach comes from the R.V. Gladue decision. This ruling requires courts to consider the unique systemic and historical factors affecting Indigenous offenders when determining a sentence. It reflects a broader principle in Canadian law, that justice should take into account the full context behind an offense, not just the act itself. Another key difference is how courts view mandatory minimum sentences. While they do exist in Canada, they are far less common and have been challenged in court. The Supreme Court of Canada has ruled in multiple cases that certain mandatory minimums can violate constitutional protections if they result in punishments that are considered cruel or disproportionate. This leads to a system where flexibility is central. Judges are expected to tailor sentences in a way that fits both the seriousness of the crime and the circumstances of the offender. Even the concept of a life sentence is handled differently. In Canada, a life sentence means the individual remains under supervision for life, but there is usually a set period before they can apply for parole. In contrast, in the United States, some sentences are issued as life without parole, meaning there is no opportunity for release. So while the American system emphasizes structured, predetermined outcomes, the Canadian system focuses on individualized decisions. One prioritizes consistency through rules, the other prioritizes fairness through discretion. And this difference, how punishment is decided, plays a huge role in shaping how justice is ultimately delivered in each country. The final difference is the most absolute, and for many people, the most striking. It's not about procedure or interpretation, it's about the limits of punishment itself. In Canada, the death penalty no longer exists. It was formally abolished for civilian crimes in 1976, marking a major turning point in the country's legal history. From that point forward, no court in Canada could sentence someone to death, regardless of how serious the crime was. That decision didn't happen overnight. For decades leading up to abolition, there was intense national debate over whether capital punishment should remain part of the justice system. Arguments ranged from deterrence and public safety to concerns about wrongful convictions and the moral role of the state. Over time, public opinion and political will shifted, leading to its removal from civilian law. The process was completed in 1998, when capital punishment was also eliminated from military law under the National Defense Act. From that point on, Canada became fully abolitionist. Today, the most severe sentence available is life imprisonment, with no legal pathway for execution under any circumstance. Now contrast that with the United States, where the death penalty is still part of the legal system. At the federal level, capital punishment remains legal, and it is also authorized in multiple states. While not every state uses it, and some have placed restrictions or pauses on executions, it is still an active sentencing option in parts of the country. The application of the death penalty in the U.S. varies depending on jurisdiction. Some states have carried out executions more frequently, while others rarely use it despite having it on the books. This again reflects the broader structure of the U.S. system, where individual states have significant control over how criminal law is applied. The ongoing use of capital punishment has led to continuous debate. Supporters argue that it serves as a deterrent and delivers justice in the most serious cases. Critics point to concerns about fairness, the risk of irreversible errors, and the uneven way it has been applied across different regions. What makes this difference so important is that it reflects two completely different legal philosophies. Canada has drawn a clear line. There are limits to how far punishment can go, no matter the crime. The United States, on the other hand, continues to allow the most severe penalty within its legal framework, depending on the jurisdiction. So while both countries aim to deliver justice, they fundamentally disagree on where that line should be drawn. And that makes this not just a legal difference, but a defining contrast in how each country views the role of the justice system itself. When you step back and look at the full picture, it becomes clear just how different these two systems really are. And more importantly, it shows how much of what people boudoir about criminal law is shaped by media rather than reality. A lot of the biggest misconceptions come from applying what's seen in American-based shows to Canada. Things like assuming every case follows the same courtroom style, that sentencing always follows strict formulas, or that the most extreme punishments are always an option. Those ideas don't translate cleanly across the border. What we've broken down in this video shows that the differences go much deeper than surface-level details. They come from fundamentally different approaches to how justice should work, how laws are structured, and how punishment is decided. Understanding these distinctions matters, especially when you're watching real cases unfold or forming opinions about how justice is handled. Without that context, it's easy to misunderstand outcomes or assume something is wrong when it's actually just part of a different system. It also highlights something important. There isn't one universal model for justice. Different countries build their systems around the different priorities, values, and legal traditions. What works in one system isn't automatically applied in another. So the next time you see a headline, a documentary, or even a dramatized version of a case, it's worth asking a simple question. Which system am I actually looking at? Because that answer can completely change how the story makes sense. If one of these differences surprised you, or changed how you think about criminal law, drop a comment below. I'd be interested to hear which one stood out the most. And if you want more videos that break down real legal systems, forensic processes, and the truth behind common crime myths, make sure to like the video and subscribe. Thanks for watching, and I'll see you in the next one.